A federal judge in Washington just refused to block Trump's executive order on mail voting, and if you only read the headline, it probably sounds like Trump just won a major court fight. But that is not really what happened. The judge did not rule that the order is constitutional, and he did not say Trump has the legal authority to reshape mail voting by executive order. What he said was narrower. The challenge is premature because the administration has not fully implemented the order yet, so the court is not stopping it right now. That distinction matters because this is how election law fights get distorted in public. A procedural ruling gets treated like a political victory, and suddenly everyone argues over the headline instead of the actual power being tested underneath it. So the question is not, did Trump win? The question is whether the federal executive branch can keep moving toward a system that gives Washington more control over mail voting before courts ever decide whether that system is legal. The executive order tightens federal involvement in mail voting and voter eligibility. According to reporting on the case, it directs federal agencies to help create state by state lists of confirmed U.S. citizens eligible to vote, tells the Postal Service to deliver mail ballots only to voters on approved lists, and requires election records to be preserved for 5 years. Supporters call that election integrity. Cleaner rolls, verified citizenship, better records, and less fraud. Critics call it executive overreach because election administration is supposed to be handled by states and Congress, not redesigned from the White House. And that is the real fight here. It is not just about whether mail voting should be secure. Everyone says elections should be secure. The fight is over who gets to change the rules and how much power a president can claim when Congress has not passed the laws he wants. States run elections. Congress can regulate federal election procedures, but if the president can use federal agencies to build voter eligibility systems and pressure how mail ballots move, then election administration starts shifting toward executive control. That is why Democrats, civil rights groups, and voting rights organizations sued. Their argument is not that citizenship does not matter or that voter rolls should be sloppy. Their argument is that federal databases are not clean enough to become the gatekeeper for who gets a ballot. Government records are wrong all the time. Names change, addresses change, naturalization records can lag, Social Security data can be incomplete, and different agencies may not match the same person the same way. That sounds boring until it is your ballot on the line, because once a government list decides whether you are recognized as eligible, the burden can shift onto you to prove the system made a mistake. That is easy to dismiss if you have flexible work hours, reliable transportation, time to make calls, and every document sitting in a folder. But for new citizens, older voters, students, military families, people who move often, or anyone whose records do not match perfectly, a database problem can become a voting problem very quickly. And this is where bureaucracy becomes power. A rule does not have to say you cannot vote to make voting harder. It can create uncertainty. It can create paperwork. It can make people wonder whether they are on the right list, whether their mail ballot will actually be sent, whether their information needs to be corrected, or whether a deadline is about to pass before they even understand what went wrong. Some people will fight through that. Other people will not. That is why small procedural changes can have large political consequences. The Postal Service part matters for the same reason, but the issue is simple. USPS delivers mail. It does not run elections. If the Postal Service is told to only deliver mail ballots to voters on approved lists, then delivery infrastructure becomes part of the election enforcement chain. The mail system would not just be moving ballots anymore, it would be helping determine which ballots move. Now, the judge did not say that is legal. His ruling was narrower than that. He said the plaintiffs had not shown the kind of immediate harm needed for the court to block the order at this stage, because the administration had not yet implemented the rules. That leaves the door open for future challenges if federal agencies actually begin carrying out the order in a way that affects voters. But that is exactly the tension. Critics want the courts to stop the machinery before it starts moving. The court is saying the machinery has not moved far enough yet, and in normal policy disputes, that might make sense. But elections are different because timing is everything. If a voter misses a deadline because the system changed, or a mail ballot is delayed because officials are operating under new federal instructions, you cannot fully repair that after Election Day. That is why premature is such a dangerous word in election cases. Wait too early, and the court says there is no harm yet. Wait too long, and the harm may already be baked into the election calendar. That does not mean every challenge should automatically win. It means the timing problem is real, and the people most affected by it are usually not the politicians arguing on television. They are normal voters trying to figure out which rules apply before a deadline hits. The unanswered questions are practical. Who builds these citizenship lists? What databases are used? How accurate are they? And how quickly can an eligible voter fix an error? Right now, those answers are not clear enough to justify public confidence, and that is the problem. When a voting system depends on invisible records, federal coordination, agency instructions, and deadline-sensitive corrections, even small mistakes can become real barriers. That is especially true if the machinery is being controlled through executive action. If Congress passed a detailed election law, at least the process would be debated, amended, voted on, and publicly owned by lawmakers. An executive order is different. It moves through agencies. It changes priorities internally. It can reshape enforcement before most voters ever understand what changed. That makes the concern not just incompetence, but power. So the real danger here is not that the judge handed Trump a final legal victory. He did not. The danger is that the order can keep moving while the central legal question remains open. Federal agencies can prepare, states can react, the public can hear conflicting claims, and the closer this gets to real election administration, the harder it becomes to separate legal theory from practical consequences. So, no, this ruling does not mean Trump's mail voting order is legal. It means the court is not stopping it yet. That one word matters. Yet. The administration has room to keep moving. The plaintiffs may challenge it again later, and the voters are left waiting to see whether a legal fight over election rules becomes a real world fight over ballot access. And that is how institutions decay, not always through one dramatic takeover, and not always through one obvious abuse of power. Sometimes it happens through process, through delay, through agencies preparing rules before courts decide the core question, through headlines that make "not blocked yet" sound like "approved." And once voting rules become unstable, people start preparing to distrust the result before a single ballot is counted.